Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA-CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Okay, now to part 2, the second and last part of the Voluntary Chapter 11 Bankruptcy Reorganization lecture. So we are going to cover the following areas. We'll spend a lot of time, there's a lot of slides on the Chapter 11 plan, a few extra slides on the hearing on confirmation of the plan. When we get to this Chapter 11 plan thing, it's a lot like the significance slides. I mean, it's just read them, understand this, make some good points in your head, take down a bulleted list that's shorter than my list on the slides, and that will help you, digest it. Might be a good idea to compare some of the Chapter 11 plan with Chapter 13, and then always just remember the best interest of the creditors test is relevant to Chapter 7, but relevant in contrast with all these others that have a plan. Maybe have your list of definitions out too while I'm talking. I'll try to remember to stop and look myself if we run into repeated terms, just to keep these words flowing in your mind of what they mean rather than bringing it to you again and not explaining it again. So if it gets repetitive for that reason, I apologize, but it's intended to help. So, motions and complaints. They can be initiated in contested matters. That's a motion. And when we have an adversary proceeding, that's a complaint. Once again, I do have a final, I've got one lecture I prepared and need to record that will cover a lot more on the procedural aspects of motions and complaints. And so hang tight for that. Contested matters are governed by Rule 9014 of the Federal Rules of Bankruptcy Procedure, and these are the matters which those matters which must be initiated by adversary proceedings are Rule 7001 Federal Rules of Bankruptcy Procedure, and those will be discussed a little more in the upcoming lecture I told you about. All right, so there's a disclosure statement or evidence showing compliance with 11 U.S.C. 1126B. And so ordinarily a Chapter 11 plan must be accompanied by a disclosure statement containing adequate information as defined in U.S.C.A. 1125A. A disclosure statement helps the creditors or equity security holders entitled to vote on a plan make informed decisions about how to vote. Acceptances or rejections of a plan may not be solicited after the commencement of the case unless a court-approved disclosure statement has been transmitted to the holders of claims or interests who are entitled to vote. So basically, the court and others won't get involved in acceptance and rejection until everyone has had an opportunity to get this disclosure statement that enables creditors and equity security holders to have adequate information. All right, so here we go with the plan. Like I said, there are probably good 7 slides or so on the plan. So there's an exclusivity period under the plan, under Chapter 11, and describe that in here. We don't. So the exclusivity period could be defined as in Chapter 11 bankruptcy, it's this window of time, and it's the window of time during which only the debtor has the right to propose a plan of reorganization. And it's designed to give the debtor breathing room to negotiate with creditors and formulate a viable plan without interference from competing proposals, which kind of explains the previous slide, why everyone needs this disclosure for informed decision. But at this point, the exclusivity period means only the debtor can do this, and that's why the statement here, only the debtor may file a plan unless the court orders the appointment of a trustee or the court for cause reduces or extends the exclusivity period time frame. If the debtor files a plan during the exclusivity period, the debtor has 180 days after the filing of the petition to obtain acceptance of the plan. And the exclusivity period for filing a plan cannot be extended beyond 18 months. And that period for obtaining acceptance of the plan may not be extended beyond 20 months after the order for relief. So everyone's got to stay in the game, get this done. Continuing on, some strategies utilized in reorganization plans. Recapitalization of the business by selling assets, refinancing, issuing securities to obtain new investors. These Chapter 11 plans are very complicated in many cases. They can reject burdensome or assume favorable executory contracts. Merger or consolidation with other entities could be part of the strategy. Bootstrap, providing for restructured payment terms payable over time. Liquidation of assets, sometimes before confirmation of a plan. All right, contents of the plan. So 2 ways that a Chapter 11 plan is confirmed. First, get consent of all impaired classes of claims and interests entitled to vote on the plan, and also by cram down. So that requires obtaining the consent of at least one class if impaired class is entitled to vote. So let's look again at the cram down definition, which is in that list of definitions in the paralegal manual to study for this. Also known as pennies on, oops, my book hit this. Sorry about that. So, cram down, also known as pennies on the dollar. A cram down occurs when a plan in a Chapter 11, 12, or 13 case is approved over the objection of a creditor or class of creditors by the vote of other creditors, usually resulting in the debtor paying less than 100% of its unsecured claims. So there are definitely some strategies that go on during this. It's a very critical point. Only credit claims that are impaired are entitled to vote, and impairment generally means that the claimant's rights are modified under the plan. To determine if a class of claims or interests containing multiple holders is deemed to have accepted the plan, a majority of holders of claims with at least 2/3 of the amount of claims within the class must accept the plan. And the goal the drafter of the plan is trying to reach is a structure that all impaired classes will accept the plan. So they're looking to get this approved. Fix one more thing here. There we go. Moving on. Mandatory provisions. So 11 U.S.C.A. Section 1123A. Returning back, we're going to find that there is a code provision providing what's mandatory. So the plan must designate classes of claims other than administrative expenses, priority gap claims, and priority tax claims. So priority gap claims are typically in an involuntary bankruptcy case. And it refers to the special type of unsecured claim that arises after the bankruptcy petition is filed, but before the order for relief. So that's the gap. So, but they end up with a priority. The gap period is the time between the filing and the order for relief. The legal basis for it, as is already pointed out, is, well, it's you can look at 11 U.S.C. section 507A3 to learn more about priority gap claims. They're placed in third priority in the distribution hierarchy after domestic support obligations and administrative expenses. So they sit pretty high up. It matters because gap claims matter because creditors who extend goods or services during the gap period do so without knowing whether the debtor will be placed into bankruptcy. And it encourages continued business continuity during this uncertain time. And the Bankruptcy Code gives these claims, as already pointed out, the priority status, which increases the likelihood of payment. An example would be when a vendor delivers supplies to a business after the involuntary petition is filed, but before the court grants the order for relief, or maybe a professional provides services during the gap period, helping the debtor maintain operations. The plan specifies classes of claims and interests not impaired under the plan. So what we mean by impaired classes of claims is the group of creditors or interest holders whose legal, equitable, or contractual rights are altered by the debtor's reorg plan. So this is under 11 U.S.C. section 1124. A class is considered unless the plan leaves their rights unaltered or cures defaults, reinstates original terms, and compensates for damages. So changes, an easy way to look at impaired claim classes of claims are those, like I said to begin with, they're being altered by the debtor's reorganization plan. So they take a special place. So it's impaired if the plan reduces the amount owed, changes the interest rate or payment schedule, converts the debt into equity, offers partial payment or payment in kind, like paying out with property instead of cash, barter system. It matters because the voting rights are important. Only impaired classes get to vote on the plan. And if an impaired class rejects the plan, the debtor may need to use a cram-down strategy to confirm it. And the disclosure requirements are important. The plan must clearly state how each impaired class will be treated. So this is a strategic consideration. They're looking for creditor support through negotiations. They're trying to trigger voting rights for plan approval and restructure some burdensome obligations at the same time. More mandatory provisions, they have to have the same treatment for each claim or interest of a particular class. So they're all prioritized. Think of each of those prioritizations as a bucket, and every claim has to be treated the same. So if they're all getting 100%, if one's getting 100%, they all, in that class, they all are supposed to get 100% in that class. So on and so forth. Every class has to be treated the same. It has to provide adequate means for the plan's implementation. So if they're retaining or selling property, if they're merging or consolidating, if they're curing or waiving a default or changing payment terms, there has to be an adequate plan to implement these areas. And if the debtor is an individual, the plan must provide for the payment to creditors under the plan of all or such portion post-petition earnings from personal services for executing the plan. Permissive provisions we're at now, which is another kind of long, I don't know how long this list, couple of slides long, permissive provisions. And those are handled under section 1123B. So the plan may impair, we've talked about it, or leave unimpaired classes of secured or unsecured claims. The plan may provide for the assumption, rejection, or assignment. So these are all permissive. The plan may provide for settlement or adjustment of claims or interests belonging to the debtor or estate. The plan may provide for the sale of all or substantially all of the property of the estate and distribution of the sales proceeds among holders of claims or interests. So again, back to strategy. More permissive provisions. The plan may modify the rights of holders of secured claims other than a claim secured by only a security interest in real property that's a debtor's personal residence. Can't use that, or of holders of unsecured claims. May provide for another appropriate provision that's not inconsistent with Title 11. So, continuing with Chapter 11 plan, there's also the modification of the plan. So once we've got that together, it can be modified prior to confirmation, but it must still meet the requirements regarding classification and content, as we've already been discussing. Modification shouldn't adversely affect the rights of the holders of claims or interest who have accepted the plan. So unless those holders can accept the modification in writing, and the plan can maybe be modified after confirmation, but before substantial consummation, meaning that this plan has not been operating so long that it's substantially met the obligations of the plan, consummation. And it may require the approval of an amended disclosure statement and approval of the plan after notice. All right, the hearing, a couple of slides on this one too. Hearing on no, there's only one slide on this. Once the plan and disclosure statement are filed, the bankruptcy court sets a hearing, and the court will consider the adequacy of the disclosure statement as part of this hearing. So they're going to look at that under the standards of the disclosure statement statute, section 1125A. The disclosure statement and notice of the hearing to consider the adequacy of the disclosure statement has to be served upon the debtor and the Chapter 11 trustee, if there is one, any committee, the Securities Exchange Commission, and all persons who have entered an appearance. Once the disclosure statement is approved, the disclosure statement, plan, and ballots go to the holders of impaired classes of claims and interests, and notice of the hearing is given to the same parties who received the disclosure statement and to all creditors. So that's what you can imagine is going on with the hearing on the disclosure statement, because again, they're going to look at the adequacy of the disclosure statement, and all the folks with an interest in that, including the Securities and Exchange Commission, will need to be invited to that hearing. Then it comes time to confirm the plan. Any party in interest may object to the confirmation of the plan. Only the holders of impaired classes of claims or interests may vote to accept or reject the plan. And there are 3 requirements for the confirmation of the plan to take place. The proponent of the plan and the proponent of the plan have to comply with all the applicable provisions of Title 11. The plan has to be proposed in good faith. Any payment for services or costs and expenses in connection with the case of the plan is approved by the court. More on the hearing. The identity and affiliation is disclosed for any individual who is to serve as an officer or director after confirmation, or any insider to be employed or retained. Each holder of an impaired class of claims or interests has voted in favor of the plan, or the best interest of the creditors test has been met. That's kind of hands down. Best interest of the creditors test being met is just sort of prima facie. We've met the burden. Each class of claims and interest has accepted the plan unless such class is not impaired under the plan. And each holder of an administrative claim is paid in full on the effective date of the plan, and certain other claims are entitled to priority will be paid in full. More on the hearing. So we're looking, if a class of claims is impaired under the plan, at least one class of claims has accepted the plan without including any acceptance of the plan by an insider. And confirmation is not likely to be followed by liquidation. So in other words, the plan is feasible. We're not seeking liquidation in Chapter 11. Despite the best interest of the creditor test, it needs to appear as it's a liquidation. All fees payable to the court U.S. trustee are paid on the effective date of the plan. And if the debtor is an individual, and if the holder of an unsecured claim objects to the plan proposes to pay the claim in full with interest, or all of the debtor's projected disposable income will be distributed to creditors under the plan for a 5-year period. If the proponent of the plan can't get all impaired classes to vote in favor of the plan, it could still be confirmed by cram down. What that terminology means. If all of the requirements of confirmation are met, other than the requirement that all impaired classes vote in favor of the plan must be fair and equitable, and it must not discriminate unfairly. What is fair and equitable differs for the holders of secured claims, the holders of unsecured claims, and the holders of equity security interests. So this is a big deal, this confirmation of the plan. Fair and equitable treatment for the holder of secured claims require the holder of the claim will retain the lien on the collateral, so they're still protected by the collateral. The collateral will be sold with the lien attaching to the sales proceeds, so the creditor may credit bid the amount of its claim, and the holder of the claim will receive the indubitable equivalent of its claim, which is a form of adequate protection that substitutes for the actual collateral. So a secured claim is really just as the reason for having security on money's loaned or rental or whatever the type of transaction was with the creditor really holds an important point of equity because of the property was maintaining some assurance, a lot more assurance than a secured claim would have. So, fair and equitable treatment for the holder of an unsecured claim also requires the holder, not also, but if it's an unsecured claim, the fair and equitable treatment of these claim holders is that they must receive property equal to the allowed amount of the claim, and the claim basically must be paid in full, or the holder of a junior claim or interest, which is in a different category in the priority list, so moving junior to the unsecured claimant category, must not receive or retain anything on account of such junior claim or interest. So you can't treat the junior claim better than you treat the senior claim. So if the debtor is an individual, the debtor may retain property of the estate, provided the debtor has paid all domestic support obligations that come due after the filing. Fair and equitable treatment for a class of interest holders. Okay, so now we're looking at a different group, and each holder of an interest receives. So in the plan, each holder of an interest receives or retains on account of such interest property of a value as of the effective date of the plan that's equal to the greatest of the allowed amount of any fixed liquidation preference to which such holder is entitled. So any fixed redemption price to which such holder is entitled, or the value of such interest, or the holder of the junior interest will not receive or retain any property on account of a junior interest holder. So this is looking a lot like the last slide, but the initial test is that each holder of an interest receives or retains on account of such interest property of a value, because they have equity interests in the debtors in the bankruptcy estate. So they're going to have to set up higher on the priority list, and they're going to have assurances that they're going to remain with a property interest. So when the plan's confirmed, this is means the strategy has gotten effective as it is, and the estate revests in the debtor now. So property of the estate goes back to vested in the debtor unless the plan confirmed or order confirming the plan has another idea. The plan provides the new terms under which the claims and interest will be paid. So we have negotiated our debts and that sort of thing. The plan may provide for a discharge of debt arising before the bankruptcy filing and some arising after the bankruptcy filing, which is natural. Like I said, business has to remain fluid. Corporations and partnerships do not receive a discharge under a plan of liquidation, and an individual may not discharge a debt that's non-dischargeable under Section 523. And second to last slide. Distribution under the plan. Upon confirmation, distributions are made to creditors and equity security holders. Following confirmation, the debtor or the Chapter 11 trustee is required to file periodic reports used for the calculation of the fees paid to the U.S. trustee. The final report, last slide, and the final decree, a Chapter 11. Fix this. Chapter 11 case may be closed upon substantial consummation. So it's gotten substantially along the way. Substantial consummation is defined in the statute. It includes commencement of distributions under the plan. So a little more background on substantial consummation in Chapter 11 is that it marks what they say is a key milestone, because it indicates that the debtor has begun implementing a confirmed reorganization plan, and it's defined in the statute provided already. And substantial consummation occurs when there's been a transfer of property, like the debtor or successor to the debtor has transferred all or substantially all the property proposed in the plan. It occurs also when there's assumption of business or management. The debtor or successor has assumed control of the business or management of substantially all the property dealt with in the plan. And there's been a commencement of distributions, which means the debtor has begun distributing payments and assets. It matters because it limits the opportunity for plan modification. It usually cannot be modified when there has been substantial consummation. It triggers some deadlines. The debtor must now file a notice of substantial consummation within 14 days of reaching this important point. And it impacts appeals. Courts may deem appeals moot if the plan has been substantially consummated under the doctrine of equitable mootness. And an example, imagine a debtor confirms a plan that involves selling assets, paying creditors, and continuing operations. Once the sale closes, the business resumes under new management, and payments begin. They've met this milestone of substantial consummation. Alrighty, that concludes part 2 of the Chapter 11 Voluntary Bankruptcy. Hooray! Moving on. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also, there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.